Now the Canadian Constitution Foundation, unless you've traded again. Just checking.
It's okay. Sorry to disappoint you, Commissioner. It is me. Commissioner Rouleau, for the record, my name is Sujit Chaudhary, and I'm counsel for the Canadian Constitution Foundation. Commissioner, as you look over the evidence and prepare your report, we would suggest that you do so informed by history. In particular, we would invite you to look back at the cabinet minutes of the last use of emergency powers by cabinet before February 2022. The invocation of the War Measures Act in 1970 during the FLQ crisis. These minutes have been declassified and they are in the CCF's evidence. At the time, the Prime Minister did not initially recommend that the War Measures Act be triggered. The Security Committee of the Cabinet had met the previous day and were briefed by the security services that there was no apprehended insurrection in Quebec. The Honourable Jean Marchand, the political minister of Quebec, sharply disagreed at the cabinet meeting. He presented unverified intelligence at the cabinet table that the FLQ was, quote, a state within a state and heavily armed. He stated that failure to invoke the act was, quote, meant the risk of losing Quebec. In the end, the cabinet came around to Marchand's view. I have no doubt that Minister Marchand acted in good faith. However, it is now accepted that he and the cabinet were deeply mistaken. There was no apprehended insurrection in Quebec. The security services were right. Cabinet overreacted in the FLQ crisis. It should have relied on legal tools outside the War Measures Act. The basic mission of the Emergencies Act was to make sure that this kind of mistake never happened again. Under the War Measures Act, the Governor and Council had nearly unfettered discretion to determine if an apprehended insurrection existed. On first reading in Parliament, the Emergencies Act only required that the Governor and Council be, quote, of the opinion that a public order emergency exists. In committee, the act was amended to require that the Governor and Council believe on reasonable grounds that a public order emergency exists. Minister Perrin-Beatty, the author of the Emergencies Act, explained that the shift from an opinion to reasonable grounds test was to, quote, guarantee Canadians the ability that the courts could rule on whether the government had reasonable grounds to believe that a national emergency existed. The same holds true for this commission. Commissioner Rouleau, you must determine whether the Governor and Council had reasonable grounds to declare a public order emergency. We say that you must conclude that reasonable grounds did not exist for two reasons. First, the Governor and Council can only have reasonable grounds to determine a public order emergency exists if it is provided with all the relevant information to enable it to make a proper decision. The government has not established that the CCF threat assessment was even provided to the full cabinet. There are good reasons to find in the record that it was not. In addition, the government has not established that the February 13th policing plan was provided to cabinet. Second, the proper interpretation of the Emergencies Act is that it incorporates the CCF Act definition of a threat to national security. CCF's own expert assessment of this event is that there was no threat to national security. In the face of this finding, the reasonable grounds test requires that the federal government provide evidence for why it disagreed with the CCF assessment. It is simply not enough as a matter of law to say that the cabinet relied on a broader set of inputs to reach its decision. The invocation of the Emergencies Act has been and should remain exceedingly rare. But now that the glass has been broken on the Act, it can be used again. When the Commission asked hard questions about the Act's use in 2022, it must also focus on the Act's potential misuse in the future and protect the right to protest, parliamentary democracy, and federalism. We thank you, sir, and the Commission Council for your exceptionally hard work, and we look forward to continuing to work with you until this process is concluded. Thank you.
Thank you.